fair amount of 501c3 work.
Hi, I'm Sarah Breitmeyer. I'm a partner in tax at Chapman & Cutler in Chicago, Illinois. And I also, like Allison, do quite a bit of 501c3 work. And in my opinion, 501c3 bonds are the best type of bonds ever to be issued.
It's a good choice coming to our panel.
Kick it over.
Thank you, Sarah. Hey, good morning, everybody. Good morning. I'm Sonny Williams, Sagittarius. Oh, sorry. Wrong camel, sorry, folks. I'm Sonny Williams. I'm a partner at Bryant Rubino in New York. Like the ladies here, I've done quite a bit of 501c3 work in my 25 years of mighty muni practice. I basically am the bond guy on this panel. We've got two distinguished tax gurus, but I am not a 103 lawyer, tax lawyer, so I'm the kind of bond person who will kind of give you the kind of bond perspective if you're not a tax lawyer at your firms. Thank you.
All right, I've got a couple of housekeeping things, which now you've heard several times already, but don't forget about your CLE credits and visiting the desk if you need to change your schedule or sign in. Q&A, polls, and materials can be accessed via our mobile app. We have 3 materials for this panel. One is the PowerPoint that you're going to see here, one is a full outline, and then we also added a short, like 1.5-page piece on financing religious institutions. We may touch on that at the end of our panel. It's not necessarily a C3 tax issue, but it does come up in the C3 context a lot. So if that's something you're interested in, I would recommend pulling up that material from the app and taking a look. If you have questions, you can use the Q&A feature. You can also stand up and use the microphone, and we'll try to pay attention to see if somebody's standing up there. We may not be able to get to all the questions today, so I'll hang out after if you want to come up and ask if we didn't get to it. But if questions come in that we can answer while we're going through the materials, I'll try to do that. If you need any other assistance, just visit the Apple registration desk and they will help you out. I'm just going to start by asking how many of you have worked on a 501c3 deal? Very good. All right. Great.
And what was the role? Were you bond counsel? Raising hands. Borrowers counsel? Okay. Underwriters counsel. Great.
Okay.
Awesome.
Good mix.
Sarah, you can get us started.
All righty. What we're going to do with the slides. Okay. So we're going to start. We're going to start with what qualified 501c3 bonds are and what are the requirements for an issuer to issue qualified 501c3 bonds. So as the name aptly suggests, qualified 501c3 bonds are bonds that are issued for the benefit of 501c3 organizations to finance tax-exempt facilities that they use in their exempt purposes. And the general structure of a 501c3 bond issue is that a state or local governmental issuer will issue bonds. In the general session, we learned that was a requirement for bond issuances that it be issued by a state or local governmental unit. And the proceeds are loaned to a 501c3 for them to use for the appropriate purposes for which tax-exempt 501c3 bonds can be issued. That's the general structure. There are situations, however, where state or local governmental issuers may issue 501c3 bonds themselves. For example, a park district. A park district is a governmental unit, but they might have significant 501c3 use of their park district facilities, like an AYSO league or things like that. If those bonds are issued as governmental bonds, they could have private business use as a result of the 501c3 use. So they may issue bonds on a 501c3 basis so that the use by those organizations is a good use for purposes of those bonds. So that's another different structure, but the most common is a conduit financing structure. So they are a special category of section 145 of the code. However, the features of qualified 501c3 bonds are such that they are not, I would describe them as a hybrid between governmental bonds and pure private activity bonds like exempt facility bonds. So you get some of the more favorable rules for 501c3 bonds applicable to governmental bonds, and then some of the rules for pure private activity bonds don't apply to qualified 501c3 bonds. And there's an exempt facility bond panel, I think, tomorrow that discusses some of those rules. But for example, for certain types of exempt facilities, you need to get volume cap allocation from the state in order to issue bonds. That's not the case with qualified 501c3 bonds. So they're a nice mix between governmental bonds and exempt facility bonds, private activity bonds, which makes them very fun, in my mind, to work on. As Kareem mentioned in the opening panel yesterday, one of the preliminary considerations and the most critical consideration in issuing 501c3 bonds is that the organization for whose benefit the bonds are going to be issued is in fact a 501c3 organization. If it is not, those bonds will not be tax exempt. So there are certain requirements for an organization to be considered a 501c3 organization. So generally speaking, the organization cannot have any impermissible private benefit to private individuals, and this generally means it must be organized and operated exclusively for one of the purposes listed in section 501c3 of the code. And there are a number of them: charitable, educational, scientific, literary, and within the charitable category, that is even broad in and of itself. So it's not just helping the distressed or poor or things like that. It's also advancement of education or lessening the burdens of government. So there's a wide range of categories that fall within 501c3. And there are two tests. One is the organizational test, and this requires that the organization be set up as a 501c3. So there are certain requirements in your articles of incorporation. For example, how to dispose of assets if you ever wind down and go to another 501c3 organization. And there are certain state law requirements as to how a nonprofit must be set up under state law. So at the time you're organizing, those things must be, present in order to actually get your tax exempt status or your determination letter. There is also the operational test, which focuses on your future operations as a 501c3 organization and making sure you're actually doing the things you said you were going to do in setting up your charter. And this becomes important later on because in looking at due diligence in 501c3 opinions, you can't just look at the organizational documents and the determination letter and say, that organization is a good 501c3. You have to make sure they've actually been operating in accordance with their exempt purpose. There also can't be any private inurement, and this really focuses on diverting income in an impermissible manner to private stakeholders, not necessarily or people involved with the nonprofit, so employees or directors or officers. Those types of private inurement issues result from excess benefit transactions, things like that. 501c3s cannot engage in lobbying or political activity, and again, they have to be organized and operated for their purposes for which they were formed. So evidence of 501c3 status, most organizations will have filed a 1023, which is an application for recognition of exemption under 501c3 of the code. It's a big long form that you need to fill out, describe what your prospective operations are going to be, how you serve your charitable purpose, what you're going to be doing. And then the IRS provides a determination letter that the organization has been determined to be based operations based on that information in the 1023, that they are a good 501c3 at that point. Those determination letters are actually available, for the most part, on the IRS's website for certain organizations where the determinations were made after a certain time period. So they can be pulled from there. Your borrower will provide you a determination letter. Some organizations don't have their own determination letters, and an example of this is organizations that are covered under a group ruling letter. So, for example, the Catholic Church has a group exemption ruling, and anyone falling within certain dioceses or certain schools, things like that, are covered by the group ruling. And there's this book called the Catholic Directory, and it's about this thick. And every year they come out with the organizations that are covered by the group ruling. So, a school district or a Catholic high school might not be covered under its own determination letter, but would be covered under a group ruling. And a lot of organizations do have those types of structures. So there are many types of 501c3 organizations that are borrowers of bond proceeds. They're listed in the slide. We see a lot of hospitals and colleges and universities, cultural institutions, museums, zoos. Those are the most common, charter schools, social service organizations, and each of them are unique in what you need to look at and review for qualification for 501c3 status. So again, in looking at the organizational test and the operational test, one of the key components is making sure there isn't private inurement, again, impermissible benefits, or diverting funds of the 501c3 organization to insiders related to the organization. And the way this can sometimes happen is if a director or an employee is paid higher than fair market value compensation, or if, for example, Sonny was on the board of a 501c3 and he hired your cousin to do some work for the 501c3 and he paid him $1 million to do the work from, things like that.
That's assuming I have the $1 million. It's a bad assumption.
And the organization does that. Those types of transactions can create private inurement. There are ways that these are addressed by 501c3 organizations. For example, in conflict of interest policies. Lots of organizations have robust conflict of interest policies to prevent some of this private inurement. Private benefit is a bit of a broader concept. It involves benefits provided impermissibly to private individuals that are more than incidental as a result of the actions of the 501c3 organization. De minimis incidental benefit is allowed, and we see this quite a bit in our financings. So for example, a 501c3 college or university, it might have a bookstore in its facilities, and that bookstore might be operated by Follett, which is a private company. Arguably, they might be getting some sort of benefit from operating within a 501c3 organization's facilities. Obviously, they're getting revenue from students and things like that. But that is more incidental to the purpose of the organization, and that wouldn't rise to the level of more than incidental benefit. And we see that quite a bit when we're doing our due diligence, some of those incidental benefits. So.
Yeah, I think the impermissible private benefit, the only kind of example I know was, I think a C3 was formed to benefit basically one subdivision, and it was like beautifying the neighborhood. And they were like, this is for these 20 homeowners and not, for a charitable class.
I was going to share this anecdote, and now I'm going to share it because you brought that up. So in the outline, there is this example of an impermissible private benefit. And I was reading the example, and I'm like, So I had a fleeting thought a few years ago. I live on a street called Edgewood, and we have what's known as Edge Fest. It's a block party, you know, big neighborhood block party, and we live on the back of a forest preserve. I'm like, maybe we should establish a 501c3 called FO, Friends of Edgewood, and we can do conservation projects, and we can throw this awesome block party, and we can, you know, put solar lights on our street, and, you know, limit this organization to members that are within a certain radius. And I'm like, and we can throw a kick-ass block party as well. So I'm like, maybe we could do that. And I'm like, reading the example last night, I'm like, that is why I didn't do that. And also I'm a risk-averse tax attorney, and I'm like, I don't think my firm would let me set up a 501c3 organization. But that is the prime example of an impermissible benefit, because arguably, if our organization did, you know, beautify the neighborhood, it lessens the burdens of government, but I'm also benefiting my property value and having an awesome party for me and my closest friends. So,
There you go.
yeah.
Okay.
All right, Sonny.
Yes, ladies. So back to the bond guy. I'm going to talk briefly about some due diligence principles that are important to you guys. I mean, being somewhat junior, it can feel at times that it's overwhelming, and you know, you're not being really told why you're doing necessarily why you're doing what you're doing. So we're just going to try to give a little bit of structure to that. So again, just to speak to what Sarah and Allison were saying earlier, you know, the whole idea is, you know, you need to determine the 501c3 status of the organization. So there are things that we do look at, as we see on the slide, the 1023 application, which Sarah spoke of, the determination letter. One thing I'll say about the determination letter, what may throw you in your more junior years is if you see a determination letter that is not fairly recent. You know, you'll see it's dated 2015 or, you know, 2010 sometimes, and the natural gut reaction is, oh well, you know, that's too old. It's no longer good. I need to get to that borrower and tell them, you know, we need something that was done like last week. One, that's not going to happen with the IRS, and two, it doesn't have to happen. As long as the 501c3 organization hasn't done anything over the years that, you know, particularly that the IRS is aware of, that would negatively affect their 501c3 status, that original determination letter is always good to close.
I thought that's really old.
Yeah.
Yeah.
Or sometimes you may not have one for an organization formed before 1969, although I will say most have gone back and gotten them. But you could, back under the Revenue Act of 1913, you could be tax exempt, and that tax exemption still carries forward, although most now have a determination letter, just for these purposes.
And the application is really helpful if you can get it, because it states, it's the premise on which the IRS granted the determination letter. It's where they set forth, you know, here's what we're gonna do, and that's what the IRS signed off on. The letter from the IRS may not be clear on exactly what the basis for the determination letter is.
And I did mention gurus earlier when I was describing these ladies. So just continuing, you know, we have the Form 990 and 990T, which includes Schedule K for tax-exempt bonds that are over $100,000 in amount. Organizational documents, which Sarah spoke of earlier, very important, particularly articles of incorporation or agreement and the bylaws. Many times you'll see the mission stated right there in the bylaws. Corporate minutes are also important. You may find out from board meetings whether or not someone has been authorized to get payment, and, you know, a director. You will see certain things like where they may have sold parts of the property that were originally financed by the bond proceeds, which is a no-no, depending on the amount of which they've sold. So those are important, as well as the next bullet, the agreements with employees, directors, et cetera, which Sarah and Allison both spoke of. That speaks to the private inurement question. And then we have the diligence questionnaire, which is the biggie. Otherwise known as the tax questionnaire. There's also a diligence questionnaire if you're underwriters counsel, but that's not as involved as the tax questionnaire. The tax questionnaire for tax diligence is a very extensive document. It includes all of the bullet points that I spoke of, and then others as well, including the description of the project that is supposed to be financed by, or have been financed by bond proceeds. It's usually a document that can stretch from anywhere from 15 to 40 pages long. And what I would recommend for you folks is, if you get your hands on one that's been prepared by your firm, if you have a 103 attorney, I would look at it. And it was something that was very helpful for me as I was getting more seniority. I looked at it, I kind of digested what these questions were and why. So that's important. Just wanted to kind of stress that.
One thing I was going to mention on the diligence questionnaire is, depending on the type of organization that is the borrower, there might be specific targeted questions. So for example, hospital systems, one of the requirements for tax exemption are certain charity care policies. So there'd be questions on that. If you're financing a religious school, that's not required to file Form 990. They're required to file a certain non-discrimination form with the IRS, so if you want to ask about that. So sometimes the diligence questionnaires have to be tailored to the specific tax exempt organization. Just something to point out.
Right. And then one other thing with diligence that I would just want to state right now, which is very important, is the post-issuance compliance procedures that all 501c3 organizations should have. It's a must, really, because that speaks to and has direct impact on whether or not the entity might do something that would jeopardize their 501c3 status. There are procedures in place that you go to the organization after the bond issue, with the conduit as well, the conduit issuer as well, and just to make sure everything is, stays copacetic, as we said.
Yeah, we have an issuer who, they have their own basically C3 post-issuance policies. They're not the C3 themselves, they're the conduit issuer, but if the C3 does not have policies, we'll attach those to the tax certificate,
Right.
and we're like, you're agreeing to implement these policies.
Yeah. And the IRS website actually has really good information on post-issuance compliance policies for 501c3 organizations, as well as general overviews of 501c3 bonds. So I would encourage you, if you need some of this basic level of knowledge of what post-issuance compliance policies should entail, to go check out the tax exempt bonds section of the website. It has some, practice guides and things like that that are useful.
IRS website.
Yeah.
I would agree. The only caveat I would say is that whenever I go on the IRS website, I kind of break out in a cold sweat. So I try not to do it that often, but I'll defer to you ladies on that.
I'm on the website pretty often.
Yeah, me too.
I'm impressed, but as I said, gurus.
Yeah.
Ladies and
Maybe
gentlemen.
over time that lessens. Build up a tolerance.
So the next thing I just wanted to talk about briefly is the due diligence and 501c3 opinions. We had a good mix of folks who are bond counsel, borrowers counsel, underwriters counsel. So what we have up there are basically the first three bullets are what I feel is key to be in that 501c3 letter, that they reviewed the IRS determination letter, and based thereon, the entity is a 501c3. And then also you want the magic language that says, based on their due inquiry, nothing has come to their attention that XYZ organization has done XYZ that has jeopardized their 501c3 status. So, you know, we had the final bullet there. What opinions are you willing to give as 501c3? Some 501c3 counsel only want to do the first bullet, and that's problematic. If you are bond counsel and underwriters counsel, and I'm telling you it's true, this guy was like, you know, I'm only going to say that I'm relying on the IRS determination letter. It's like, really? You're doing your job? Okay, fine. Go watch Netflix.
I know, that's really not giving you a lot of comfort.
Yeah.
Firms.
Because everyone can
Even
read
a
a
bond guy
determination
knows.
letter. You
You know
have
what
to
I'm
make, you have to make sure, again, they've continually operated in accordance with that exempt purpose.
Exactly.
And, you know, as bond counsel, you are giving a will level opinion that these bonds are tax exempt. You cannot accept anything less than an opinion that the organization is a tax exempt organization. So I was just telling Allison last night, I'm working on a deal right now, and it's an interesting deal. Whereas we showed them what the 501c3 opinion should look like. They came back and said, based on the determination letter, this, and this, this organization should be a 501c3. I'm like, should be. I'm like, these bonds should be tax exempt. I mean, so sometimes you have to educate. I think somebody mentioned yesterday the Neville white paper on the 501c3 bond opinion. I usually just shoot that off to counsel and be like, we can discuss. And people phrase it different ways. So.
And there are different levels of opinion that different firms are willing to give. And you just kind of try to be aware of it up front, like early in the deal, so that as bond counsel, maybe you need to fill in some gaps. Like some firms will cover unrelated business income and use of the project, and they'll say, like, the use of the project is related to the exempt purposes, there's no UBIT. Some firms will not go into that at all, and they think that's bond counsel's job. And that's fine, you just need to know up front, what sort of issues there are, whether they're going to be tough ones for you to deal with as bond counsel, to make sure you have time to do due diligence and get comfortable with it yourself.
Another thing you see in opinions is sometimes you're requested to give a no private foundation opinion. A private foundation is a 501c3, but if an organization is a private foundation, it just doesn't have the general support that a public charity has. So there are additional rules that you want to make sure are complied with if there is a public or a private foundation. So that's another sort of example of where you want to know that up front.
Yes, ma'am.
CLE code 557.
Okay, so Sarah already mentioned that these are kind of hybrid bonds. They're like a little bit governmental and a little bit exempt facility qualified private activity bond. Previously, before the 1986 Tax Act, 501c3 organizations were treated just the same as governmental entities for bond purposes. And as we mentioned in the general tax session, there are still like some old regulations and stuff that have carried forward and are still used. And those can be a little bit confusing with respect to C3 bonds because those regs still treat them as if they're governmental entities, but they're not anymore under the statute, because the statute trumps the old regs. So sometimes we'll get questions like, well, doesn't this not apply to C3s, or aren't they just like a governmental entity? In the past, yes, but not anymore. So as Sarah said, they get some of the rules that relate to governmental bonds apply to them, like private business use, which we're going to go into in some detail. And some of the private activity rules apply to them, like you have to have a TEFRA hearing and public approval. There's a limit on the cost of issuance that you can pay with bond proceeds, but you don't need volume cap. You can acquire land without limitation. There's a limitation for exempt facilities on how much land you can acquire. So just again, there's, you really have to be careful with the C3 as to which rules apply and which ones don't. So the basic requirements for your 501c3 bonds are in section 145 of the code. And the first one is an ownership requirement. And this is 100% requirement. All property financed by the net proceeds of a qualified 501c3 bond issue must be owned by a C3 or a state or local government throughout the terms of the bonds. So that is very important, and 100% is 100%. So that does, it's possible to have faults there. So you really do have to be careful and make sure that the C3 understands that. And then there is a use requirement, and at least 95% of the net proceeds must be used by a 501c3 organization engaged in exempt activities or a state or local governmental unit. And this is where you sort of veer into the private use rules. And again, as we mentioned the other day, federal government is not a good use for this purpose. They're considered a non-governmental person. So we often have C3s let other C3s use their space, and it's important that your 501c3 leasing out that space or providing that use, if that's within their exempt purpose, and that the C3 coming in to use the space is using it for their exempt purpose. So everybody has to be doing their exempt purposes all the way down the line. Okay, we'll talk about the ownership requirement in a little more detail. Obviously, your nonprofit corporation or your 501c3, that might be the entity that is the ownership entity. But sometimes there are other types of entities involved in the financing. There might be a limited liability company. Some C3s, particularly those that kind of own a lot of property, will set up a new LLC for every piece of property that they acquire. There might be a partnership or a joint venture. So the way that we analyze these is there's a look-through treatment. So you're looking through the LLC or the partnership at the members of that organization. So that's in the 141 regs. They spell that out very clearly. I think it was 2015 it was added, but it was helpful to have that rule laid out. An LLC is treated as a partnership for tax purposes. It's more a state law type of entity. So for the IRS, it's treated like a partnership unless you elect to be treated as a corporation. So anytime we have an LLC, we make the borrower say that they're never going to elect to be treated as a corporation, because if that becomes a corporation, that is not a C3, and you can't look through a corporation to another corporation. So there's a big distinction there between those types of entities. But we do a lot of LLCs. It's easiest if it's single member. But we've done one where it was, the deal was called 2 schools, and it was literally 2 schools that were going to share a school space, so they formed an LLC with both the schools as members, and we're like, okay, as long as you never change the membership and you don't elect to be a corporation, we can finance the property. And also, joint ventures are often treated as partnerships, so that's something to think about.
Yeah, I was just going to make a point on the single member LLCs. Sometimes you do have a sole member and a corporate parent that is a 501c3 organization itself. So that single member LLC is disregarded and relies on the status of the parent 501c3 or the sole member. Again, you get reps that they'll never elect to be treated separately as a corporation, but you rely on the sole member's 501c3 status. And then there's a question of legal title versus ownership for tax purposes. Just to be aware that you're looking for ownership for tax purposes. So somebody may be the title holder, but for some reason they're not a federal tax owner. There is the ability to finance leasehold improvements, tenant improvements for C3s. I've done this a couple times. They maybe have a long-term lease in a building that they do not own, and they want to make improvements to their space. You can do that with tax-exempt debt, provided that either the improvements can be readily removed from the leased property and the lease allows them to take those improvements with them, or what I see more often in my deals is that the leasehold interest exceeds the expected economic life of what you're financing. So maybe you're financing some
equipment that's like stuck in place or some improvements that have like a 15 or 20-year life, but the lease is a 30-year lease. And then you know that they're gonna be using those assets for the full expected life of the assets.
How do you analyze that when there are like termination provisions?
They really, I mean, they have to be pretty limited
Yeah.
termination provisions.
Yeah.
I've had,
Like if
somebody asked if they could do it when it was like a renewable lease every 5 years, and I was like, no, you have to have the right and expectation that you're gonna be in there for the whole life of the asset. The other party can't be able to kick you out at any point, unless you really violated the terms of the lease in some way.
Yeah, and I would, like in that case, I usually get representations that say we reasonably expect to be in the property for the whole term of our lease, and we don't expect to end our lease term early.
Yes, absolutely.
And the lessor can't kick us out.
Now we're gonna move from the ownership to the use requirements.
Okay, so as Allison mentioned, and I mentioned it earlier, and 501c3 bonds are somewhat of a hybrid, so they have private business use restrictions that are similar to governmental bonds. I don't know if you went in the general session yesterday about how governmental bonds can get a 10% private use limit. 501c3 bonds don't have that. They have a 5% private business use limit. And cost of issuance counts against your private use limit. So 95% of the net proceeds of the bonds must be used for a good use or non-private use. And net proceeds is defined as the proceeds from the sale plus investment earnings minus sale proceeds deposited in a reserve fund. So if, for example, you had a $20 million bond issue, $500,000 was put in the reserve fund. That's reasonably required. If you have $19 million, $500,000 a bond. However, there is a rule that restricts the amount of non-hospital bonds an organization can have outstanding to no more than $150 million. The rule doesn't apply to bonds issued on or after August 5th, 1997 for issues for which 95% of the proceeds are used to finance capital expenditures. So a lot of your new money deals will not be subject to this limitation. However, oftentimes you run into deals where you may be refunding bonds and you might have a chain of refundings. So for example, if I were issuing 2023 bonds right now and they were going to be $30 million and they refunded some 2014 bonds, and those 2014 bonds refunded some 2004 bonds, and those 2004 bonds refunded some 1996 bonds.
This happens, by the way.
Yeah,
Seriously.
Yeah, this does
So
happen.
be ready if you haven't seen it already.
Yeah. My $30 million bond issue is going to be subject to this $150 million limit if my bonds are not hospital bonds. So it's something to be aware of when you are tracking a chain of refundings. The farther we get out from 1997, the less this comes up, but there are some hairy allocations that have to sometimes be done with this. And then sometimes new money issues are subject to this limitation because for 501c3 bonds, you can finance things like interest past a placed in service date. It's not treated as a capital expenditure. You can finance some de minimis working capital, and that can result in less than 95% of the proceeds being used for capital expenditures. So in that case, your bond issue is going to be subject to this $150 million limit. Another thing just to point out is, most people in their tax documents or tax agreements will have this date that says, 95% of the proceeds in a new money financing will be used to finance facilities on or after, incurred on or after August 5th, 1997. People always ask, they're like, did you forget to take out that date? Should it be the issue date? And it's like, no, there's a reason why, and then you have to explain the tax law reason, and they're like, I'm so sorry I asked that question. But this is something that does come up and that you should be aware of in looking at new money financings where there might be working capital or chains of refundings.
Residential rental housing is a sort of a special category. I do a lot of 501c3 senior living facilities, and that kind of falls into this pot as well as low and moderate income housing. And this slide, I don't know why it carried over that $150 million from the last slide. That's not relevant now. Moving on. So essentially, the IRS, actually Congress, put a limit on 501c3s financing residential rental housing. Basically, they didn't want them acquiring existing housing that maybe should have like low income restrictions on it, and just like, because they're a C3, being like, we're a C3, now we own this housing and it's tax exempt and we're not putting any low income restrictions on it. So the IRS kind of came up with these rules. And it's one of three categories. If the bonds finance new residential rental property, that's the first rule, you're good. If the bonds finance qualified residential rental property, which is essentially putting you under the rules for multifamily housing exempt facilities in 142. So there you have certain low income set-asides that you have to have in place. So if you're acquiring an old building that's already in service, generally you're going to have to meet the low income 142 restrictions. You can also finance property, acquire property, and then substantially rehabilitate it within 2 years. I've never seen anybody use this because it's basically 100% rehab requirement. It's huge. So generally, like, that one's just not used very often. So usually we're looking at the first two. Is it subject to the first use rule, in which case we won't have to do the 142D set aside? Or are we just going to go ahead and operate it as a low income project, which a lot of C3s are fine with because that's their mission.
Right.
And so they're okay, putting a reg agreement on the building and filing the forms and all of that. So the first thing you actually have to look at is whether you have residential rental property or not. The definition is housing units that are not used on a transient basis, which provide complete facilities for living, sleeping, eating, cooking, and sanitation. And then there are also exceptions, like hospitals and nursing homes are not residential rental property. And that generally is tied to the level of service that is provided. So step one is all or any part of the facility comprised of complete living units. So generally in a hospital, no, they're just rooms where somebody might sleep on a transient basis. They don't have a kitchen and a bathroom in their room necessarily. Like it's obviously temporary. It doesn't usually meet the requirements for residential rental property. So usually there are a bunch of revenue rulings and some PLRs that talk about what makes a complete unit. I feel like it's changed over time. It used to be kind of easy to fall out of the complete unit designation, and it's gotten, like now you can do single residency SRO things, which are basically just a room. But in certain circumstances, those are considered complete facilities. So determining whether or not you have residential rental property that may be subject to 145D, we call it the Donnelly Amendment. You might hear that. That's what it's referring to, are these special residential rental property rules that apply to C3s. So if you have residential rental property, then step two is what are the services provided? And the standard is generally if there are continual or frequent nursing, medical, or psychiatric services provided, then you're not residential rental property, so you don't have to meet the low income restrictions or have to meet the first use rule. As I said, I do a lot of senior living, and this is super important. It comes up a lot. Senior living facilities, your charitable purpose is generally assisting the elderly. It is not helping the poor distressed. They are not looking to provide low-income housing. They are looking to provide very ritzy, nice housing to seniors. So they do not want to have low-income set-asides. Their project just totally doesn't work if you have low-income set-asides. So they have to make sure that they are not subject to the requirements of the Donnelly Amendment. Like, they need to fall outside it in some way. And they're so interesting now. Like, their senior living facilities are really interesting, and I don't know if you guys have experience with them either just like personally or in the bond world, but now it's like this whole continuum of care, right? You move in and you just have an apartment and you're doing your own thing. But then if you need more services, you keep stepping up to higher levels of service. And you have to figure out where the tipping point is between independent living, assisted living, which usually does not meet this level of service, to where you basically get to nursing home, which is not a term they like to use anymore, but that's, you know, you've got memory care units and figuring out, oh, it's the memory care, like how often is the nurse available? Do they have their own kitchen? You're allowed to just have a microwave. They're afraid they're gonna hurt themselves with an oven. So, you know, a microwave and a mini fridge is that residential rental housing. So it comes up a lot in the senior living context.
Yeah, and it's the first use requirement sometimes becomes an issue when senior living facilities are sold to other 501c3s, and you know, you want to structure it so that if you're refinancing the debt, that it's a refunding and not treated as an acquisition financing, because you could have a problem with acquisition of existing residential rental property.
Gonna wrap up that one. Keep hitting the green button.
How are you doing, folks? You doing all right?
There it goes.
I hope you realize how bright it is on this stage. There have been many times I've wanted to put these on, but I didn't want to create a bad impression, but it is bright. We're doing this for you.
Okay, there's a lot on this slide. So section 147 has a lot of the rules that are applicable to exempt facilities and other private activity bonds. And some of those are applicable to 501c3 bonds. The average maturity of the bonds cannot exceed 120% of the average reasonably expected economic life of the property financed or refinanced with the proceeds of the bond issue. You have safe harbors, as we're always talking about. There are certain safe harbors for different types of buildings and equipment that you can use to determine the economic life, or you can use facts and circumstances. But very often your issuer or your borrower will be like, oh, we expect this to have a 50-year life. And you need some backup for that, especially if it's significantly over the safe harbor. We use the safe harbors generally anytime we can. But there are times where, under the facts and circumstances, if they have some backup information, it helps too if they're depreciating it over that amount of time on their books. That's a helpful fact. You can use a different life than the safe harbors. There are the no skyboxes, airplanes, gambling facilities, or liquor stores. For exempt facilities, they can't do health club facilities, but 501c3s can. And we do see YMCAs, and the senior living facility would have a health club maybe as part of it, but C3s are allowed to do health club facilities. Then 147F, as we've mentioned before, that's the TEFRA hearing and approval. 501c3s are subject to those rules, so they do need to have a TEFRA. And they have the 2% limit on cost of issuance being paid with your bond proceeds. So all of those rules are ones that apply to exempt facility bonds and to 501c3 bonds. Section 148, arbitrage, rebate, refunding, those apply to all the bonds, so they apply to C3 bonds too. And then the 149 rules that I tried to speed through in the general tax session, those apply to 501c3 bonds too. So the bonds have to be in registered form, federal guarantees are not allowed. The federal guarantee rule is actually a little bit tricky because there are so many exceptions that you kind of forget about it because there's like an exception for everything, it seems like, until suddenly you're not in an exception and you're like, totally forgot to think about whether there's a federal guarantee. No hedge bonds, that's about spending down your reasonable expectation test. So generally, we want our borrowers to expect to spend it down within 3 years. And the hedge bond rules, I feel like they come up most often when you're doing a refunding and they just simply failed to spend the proceeds. Sometimes they fail to spend the proceeds until the point that you're refunding. So, it's 10 years later and you're like, okay, what funds and accounts do you have? And they're like, oh, we still have $2 million in our project fund from 2010. And okay, that's not great. Let's figure out how to deal with that. So for your refunding bonds, your no hedge bond status is based on the prior bonds. So you have to be pretty darn sure that the first set of bonds were not hedge bonds to issue refunding bonds and have to be tax exempt. You file Form 8038. That's the one that exempt facility bonds used to governmental deals use the -8038G. So you have to file that, and then for 501c3s, they're supposed to be filing Schedule K to their 990. That is an area where we see a lot of non-compliance. Honestly, we just had a refunding come in where they've never, we're refunding tax exempt bonds and they've never filed a
Done the Schedule K.
K.
Yeah, the Schedule K is also very important during diligence as well, because you can see how organizations are filling it out. And I don't know, Allison, if you are asked this, but I'm sometimes asked to review them, and a lot of times the information on them is incorrect, and that could trip up an audit. So if, for example, there's a line for use of proceeds, and on their 8038, they clearly showed less than 2% of proceeds being used for cost of issuance. But then you look at their Form 990, and it's 5%. It looks like are being used for cost of issuance.
Definitely seen that.
Yeah. So if you're asked to look at it, and you can educate your client on how to fill it out properly, that's very important, because if your Schedule K says 5% being used for cost of issuance, the IRS puts that in a little database, and that little database can go to the IRS taxes and bonds audit unit, and they can audit on that basis. So it's a good thing that if you are reviewing a Schedule K for diligence purposes, to just kick the tires and make sure it looks generally correct. There are no red flags in terms of how people are filling it out.
CLE Code 116.
Still means. So arbitrage and rebate, the only thing I want to say is this, there are other panels that go into more detail on this. The endowment funds and fundraising campaigns are things that come up a lot for C3. So being aware that those might be replacement proceeds of your bonds that are subject to arbitrage restrictions, and always evaluating those funds to see if they're replacement proceeds. So that's really the only thing I want to flag there. You may have to yield restrict funds, or you can sometimes help your clients with the wording of fundraising campaigns to make sure that it's broad enough that it doesn't trigger the replacement proceeds rule.
And if you want to learn more on arbitrage, I'll put in a plug for our panel this afternoon. Be prepared to be amazed. All the rules, all the tax rules.
And this is the reimbursement rules. That's essentially when you want to reimburse yourself for costs of the project that you paid prior to the bond issue date. There are just timing requirements. You can reach back 60 days before you adopted an official intent. And this is an area where C3s, again, are a little special. Either the governmental issuer or the C3 can adopt the official intent. For exempt facility bonds, only the governmental issuer can. So C3s are given a little leeway here. And then you can go back basically either 18 months or 3 years, kind of depending on when your project was placed in service. You can finance 20%, use 20% of your bond proceeds to reimburse for preliminary expenditures. That's like architecture and engineering stuff that happens prior to the project's construction starting. And then there's a de minimis exception. I'm starting to speed through a little because we only have 10 minutes left.
Okay. I'm going to go through this slide relatively quickly, just because acquisition financing can get complicated. But basically the same general rules for 501c3 bonds and governmental bonds for refundings apply. Before 2018, before 2018, entity, and you could do advance refundings of qualified 501c3 bonds. Obviously, there are no advance refundings now. However, there are special rules for acquisition financings where a refunding or a defeasance of debt of a previously unrelated party that is acquired in an asset acquisition. So, for example, a hospital system A acquires a hospital system B, and there are unrelated parties. And in connection with that asset acquisition, hospital system A assumes the debt of hospital system B, their tax-exempt bonds. There is an exception if hospital system A wants to issue its own tax-exempt bonds to refinance those tax-exempt bonds of hospital system B within 6 months of the acquisition. That is generally not treated as a refunding transaction. It's treated as a new money refinancing. And that allows essentially the acquiring hospital entity to advance refund the old debt associated with the facility. There are various complicated rules in terms of how you can allocate what you're acquiring, what assets you actually say your tax-exempt bond proceeds are being used for. There are particular rules related to acquisitions between affiliated persons where the acquired party has an interest on the board of the other entity. But the important takeaway here is that there are transactions where it looks like a refunding and it smells like a refunding, but it's not. It's treated as new money. And this can be problematic in the case of residential rental property or senior care facilities because of the requirements against acquisition of existing property. So you might want, in that case, to have the transaction be treated as a refunding.
Is this from you?
So it's good, okay.
Yeah.
Oh no, I jumped ahead somehow.
Okay.
I can take it back to
We
the bond guy.
Yeah, we already talked about
Yeah,
that.
so back to the bond guy. I'm just gonna talk briefly, because I know I only got 7 minutes and 4 seconds. Just gonna talk about the common financing structures for 501c3s. I'm hoping and assuming everyone knows what a conduit issuer is and kind of how it plays the role, but when you have the conduit issuer and the single borrower, you're typically dealing with the loan or financing agreement, and then you have the note, which is the evidence of the debt from the conduit issuer to the borrower, and then the bond is issued by the conduit issuer, which is also evidence of the debt between the conduit issuer and the bondholders. So that's how it all comes into play. The governmental issuer and the borrower make the election to treat the bonds as 501c3 bonds. So next slide, Allison. So basically, here we are at the main bond document for more than one borrower, where we have the first bullet, the MTI, as we call it, or Master Trust Indenture. It's designed to pool credit of multiple 501c3 organizations and non-exempt facilities. I'm sorry, entities. It's a big, obligated groups are big in the 501c3 space. When you're pooling the credit, it's very important for, say, a hospital or healthcare facilities, because they traditionally have issues with poor cash flow and lower credit if they stand on their own as a result. So when you pool the credit together of several healthcare facilities, it tends to bump up the credit worthiness of the obligated group. But the obligated group, it's important to realize that each group member is severally liable for the debt that's issued under the master trust indenture. The MTI also, it's what we like to say in the industry, it's your controlling document from the establishment of the bond issue all the way down. And it has all the quote-unquote plumbing, what we like to say plumbing, which is up there as, you know, you're consolidating financial and operating covenants, such as, you know, debt service coverage or, you know, additional bonds tests for additional bonds that you're going to issue. It also will allow for the issuance of taxable and tax-exempt debt. It's usually between the trustee and the obligated group representative, which is typically the primary borrower. You know, you're basically, you have, as I said, it's a controlling document. You don't have to renegotiate terms for each subsequent issue. You basically will use supplemental indentures, which ratify the MTI and also give provisions that may be specific for your future issuance, like, you know, maybe bond insurance, things of that nature. So we also have down there that the obligations under the MTI have greater covenants and restrictions and security. Usually there's restrictions on additional debt or unless debt service ratios are met. And there's also another common one that we see is a restriction on property that's being transferred outside the group. The corporate style master indenture is basically used for what are called systems, which are all of the entities that are controlled by a primary borrower. That MTI, that corporate style MTI, is typically where you have covenants that are based on the the audited financials of the system, quote unquote. So if you see such and such healthcare system, that is typically what's going on, and that MTI is usually going to be fashioned in that way. The MTI also gives you the waterfall, flow of funds, conditions for, you know, not to allow arbitrage for tax-exempt bonds, etc. Like I said, it has all the plumbing. I have 1 minute and 39 seconds. How
We
am I
don't
doing?
ever get to this slide.
Well, we're here. We got 90 seconds. So this is last but not least. But it has been a pretty big issue over the years for religious 501c3 institutions. There's always been a tension between the Establishment Clause, the Free Exercise Clause, as well as state law provisions. There's some major cases that have come around. Lemon v. Kurtzman was the first one that established the 3-prong test, which says that the legislation that is permitting the state aid must have a secular purpose. The primary purpose of the statute, the primary effect of the statute cannot be for the advancement of religion. And then 3 is the statute cannot lead to an excessive entanglement with religion. And then Hunt was I believe the only Supreme Court case that has been specifically decided on whether or not the issuance of bonds and the use of bond proceeds for overtly religious institution. In the case of Hunt, it was a Baptist college. Whether that is violation of the Establishment Clause. It's a fluid situation. If you're interested in it, as Allison said, there's information about it, particularly the pervasively sectarian test. It is fluid. In recent years, there's been more of a protection of the Free Exercise Clause by Supreme Court cases, reasoning that you can't discriminate, quote unquote, against religious schools and other institutions. So
Yes.
that's
It's a
where I'm
moving-
going to stop.
it's a
I'm
moving
trying to
target.
do it as
It's a
quickly as I
moving
can.
target, but don't finance chapels.
As Stephen A. Smith says on First Take, it's fluid. It's fluid. That's all we got, folks.
Thank you.